6. Right of sale. The power and right of a mortgagor to sell properties largely depends on whether or not it is a legal mortgage created by deed. It is automatic. The mortgagee need not go to court to enforce it. However, 3 conditions must be fulfilled before the statutory right of sale can arise. A. The mortgage must be by deed. B. There is no contrary intention against sale as contained in the deed. C. The mortgage money must become due. Section 19 sub 1 of the Conveyancing Act. Section 1 to 3 of the Property and Conveyancing Law. These 3 conditions are conjunctive and not disjunctive. The right of the mortgagee can only be employed if the power of sale arises and becomes exercisable. NAB Limited and UBA PLC 2009 Nigerian Regular Report Part 671 at page 1. Conditions to be fulfilled before a power of sale can become exercisable are: 1. A notice requiring payment of the mortgage sum must have been served on the mortgagor and there is default of payment for 3 months after such service. 2. Some interest under the mortgage is in arrears and unpaid for a period of 2 months after becoming due. 3. There is a breach of some provision or covenant contained in the mortgage deed, Section 20 of the Conveyancing Act, Section 1 to 5 of the Property and Conveyancing Law. Either of these 3 conditions suffices. Protection of innocent purchaser. A purchaser who purchases a property before the power of sale arises will now acquire a good title. A mortgagee's power of sale becomes exercisable if it has arisen, and once it has arisen, the title of a subsequent purchaser will not be affected by its improper or irregular exercise, and the sale will be regarded as valid. Nigerian Advertising Services Limited and UBA 1999 LCN 0504CA. A sale extinguishes the mortgagor's right of redemption. Conduct of sale. A. Sale by public auction. B. Sale by private contract. In the case of a sale by public auction, 7 days notice of the intended auction must be given. Section 17 of the Auctioneer's Law. Where the sale is made at an undervalue, it has been held that it does not necessarily evidence bad faith. However, where the mortgagee sells to himself directly or through an agent to his cronies, relations, the court will infer bad faith. A mortgagor is only required by law to obtain a proper price and not the best price for the property when exercising his power of sale. To vitiate the sale, it must be shown that the sale was made at a fraudulent or gross undervalue. Okonkwo and CCB SC 114/1999. Circumstances in which a sale may be set aside are: 1. Where there exist elements of corruption or collusion in respect of the sale of the property by the mortgagee. 2. Where the sale is at such a low value that it raises an inference of fraud. 3. Where there is evidence that the money has been paid in full. 4. Where the mortgagee sells to himself, privies, or cronies. Proceeds of sale. Where the mortgage is completed, the mortgagee should use the amount of money realized to satisfy the mortgagor's indebtedness to him, and if there is another mortgage, he should use the balance to settle the other mortgages. Otherwise, he must return the balance of the sale to the mortgagor. This is because the mortgagee is a trustee of the proceeds of the sale. Thus, the mortgagor can sue the mortgagee for the surplus where he refuses to give it. Proceeds of sale may be applied in the following order: 1. Pay up all mortgages having priority. 2. Pay commission to the auctioneer and other expenses incurred in the course of the sale. 3. Pay up all outstanding interest. 4. Pay up other outstanding mortgages, if any. 5. Pay balance to persons entitled to equity of redemption. Section 21 sub 3 of the Conveyancing Act. Section 17 of the Property and Conveyancing Law. Very important. Where the proceeds of the sale does not satisfy the principal and the interest, the mortgagee can sue the mortgagor to recover the balance. Foreclosure. This is an order of court by which the equity of redemption of the mortgagor and all persons claiming through him, including subsequent encumbrances, are extinguished so as to vest the mortgage property absolutely on the mortgagee. In foreclosure, equity destroys the equitable right to redeem. This order vests the entire interest of the mortgagor on the mortgagee, subject only to other mortgages that are in priority above him. The court would normally grant a foreclosure order nisi, which would first last for 6 months. If after the 6 months the mortgagor still fails to redeem upon another application by the mortgagee, the court will grant a foreclosure order absolute. Remedies available to a mortgagor are: 1. Legal right to redeem. 2. Equitable right to redeem. 3. Equity of redemption. The legal right to redeem is expressed in the deed of mortgage by virtue of the agreement of the parties. Upon the expiration of the specified date for payment, the legal right to redeem expires. Equitable right to redeem is the right granted by equity to the mortgagor to still recover his security by paying the mortgage sum and the interest even though the time fixed for the payment of the money has elapsed. Equity of redemption is an estate in land that could be sold, disposed, or even mortgaged. It is the equity of redemption that is destroyed or extinguished by a sale, foreclosure, or release by money. Discharge of mortgages. 1. Legal mortgage by way of self-demise or assignment in Conveyancing Act states. This is usually discharged by deed of discharge, deed of surrender, or deed of release. Deed of discharge, release, or surrender is registrable in the lands registry where the mortgage has been earlier registered. 2. Equitable mortgages. These are discharged by receipt of payment of principal and interest. Where the payment is made to the mortgagor, solicitor, or agent, the receipt must be by deed. 3. Legal mortgage created by charge by deed under the property and conveyancing law states. These are discharged by statutory receipt. These statutory receipts are not registrable. Consequently, the encumbrances will still be reflected on the property at the lands registry. Where the mortgagor is a company, a memorandum of satisfaction is to be executed in its favour upon repayment of the mortgage sum, Section 204 of the Company and Allied Matters Act. The company is also advised to complete and file Form CAC 9. 4. Discharge by court. Despite the covenant restricting redemption of the mortgage by the mortgagor can still redeem. It can apply to court. The court will order that the mortgage money be paid into the court. Upon the payment, the mortgage is duly discharged. There can also be an endorsement of the release on the deed of the legal mortgage. Where the third party pays the mortgage sum, the right of the mortgagee transfers to the third party. The mortgagor becomes indebted to the third party and the mortgage continues. Very important, the mortgagor may decide to sell his property and use the proceeds to pay off the loan. In this instance, there should be a tripartite agreement between the mortgagor and the mortgagee as the assignors and the purchaser as the assignee. In states that operate the Conveyancing Act, the mere fact that the mortgage sum has been repaid does not discharge the mortgage. The mortgagee holds the interest in trust for the mortgagor pending when the deed of release has been executed. In the Property and Conveyancing Law states, the mere fact that the mortgage money has been paid absolutely and instantly discharges the mortgage. Very important. As a solicitor, ensure that you retrieve all the title documents from the mortgagee upon discharge of the mortgage. Where the mortgagee refuses to return the title deeds, he can be sued for debt tenure. Quick glance notice powered by Rollums and Luxury, your choice real estate agency in Lagos, Nigeria. Address is number 7 Tower Conic Close of Inimai Crescent, Igbefon, Lekki, Lagos, Nigeria. Tell WhatsApp 08142775425 09152691367 and send your emails to rollumsandluxury@gmail.com, Instagram rollumsandluxury, Facebook rollumsandluxury. You can call them for all your real estate questions. For sponsorship and advert placements, please contact 09125921620 or send an email to resistandpartners.chambers@gmail.com.